With more of the Dan Williams Show on WKAC.
Okay, we're back with what I consider to be a very interesting conversation here. It's a lot to do. Now, Mark, you said you were going to drop in on this situation. Go right ahead.
Well, one of the things that I wanted to mention, in the last couple of years, the Alabama Family Rights Association had proposed legislation called the Alabama Children's Family Act.
Yeah.
That legislation basically totally revamped family law in Alabama. And we have decided that that's not the way that we need to go with our legislation. And so we've dropped that. The Alabama Children's Family Act is no longer being presented. All we have done is taking the existing joint custody law that Dinah mentioned earlier, 30-3-150, that's been on the book since 1997, and we've added some amendments to it to basically give the judicial system some guidance on what the official policy of the state should be.
Sure.
And so that's all we've done is added some amendments to that. Another thing I wanted to mention to you as well, that we're talking about how do we determine fit parents and that type of thing. In 2011, the Alabama legislature passed a joint Senate resolution that actually went to U.S. Congress that basically says that fit parents act in the best interest of their children. And it was signed by the governor on April the 21st, 2011. And it basically says that there are many instances where the Alabama laws is not current. They need to be updated. And let me see here. I think Kenneth's got something here. And basically, here's what it says. It says the right of fit parents to direct the upbringing and education of their children is a fundamental right protected by the Constitution of the United States and the state of Alabama. And our nation has long pursued the path of relying first and foremost on parents to meet the real and necessary needs of children. And the U.S. Supreme Court in Wisconsin v. Yoder basically had that it's the primary role of fit parents in the upbringing of their children is now established beyond debate as an endearing American tradition. And the resolution goes on to say that children are best served by the continued practice of requiring proper proof of harm before the government may intervene in the family to override parental decisions in any sphere of the child's upbringing. And so we're asking the legislature to amend the current existing law, and all we're asking the legislature to do is enact Alabama law that y'all have already sent to Washington that said, in a joint Senate resolution that says we think this is the best practice.
Yeah. So, it's a lot of times our core beliefs, our basic beliefs that we hold near and dear, when we get into a legislative session or whatever, we may pass legislation that's totally opposite of what we think we believe. I think the Alabama legislature is full of people who doesn't think the government at any level ought to be dallying with people's lives, certainly their children and everything. We know, I mean, that's just a given for the Alabama state legislature. But whether or not we can make that leap there to change the legislation, to enforce that, you're not going to be have your rights taken by whatever level of government. That's,
Dan, we had Judge Woodruff here in Limestone County a month ago ordered that a parent could not call the child by its middle name.
Now, wait a minute. Say that one more time.
Judge Woodruff, Limestone County Circuit Court judge, ordered a parent not to call his child by its middle name.
Well, I two things crossed my mind. I'd like, what's that child's middle name? That's the first, and I'm not making fun of that. I mean, that's the first thing I thought about. But why would a judge?
But how many parents? Gosh, I mean, my mom, grandmother,
my mama called me.
Everybody's mama called them by their middle name.
When you were in trouble.
You're in trouble.
Yeah,
my middle name is Daniel, and I've been called Dan.
But it was all because the other parent and the other parent's attorney, and I don't know the reasons why, just thought that parent didn't need to be calling the child by its middle name. And my point is that's overstepping the bounds a little bit, in my opinion.
That I don't.
And everybody I've talked to thinks that.
Yeah, well, I don't understand it. I just, there must be something else involved with that. But well,
we have judges.
Anyway.
We have judges in Alabama telling parents what time they put their kids to bed at night. they can only talk to the other parent for 30 seconds on the telephone. And that's and I could go on, I could tell you hours, because I talk to hundreds of parents throughout Alabama that I hear these stories, and I'm like you, Dan, I think, well, there should be something, maybe there's something else going on. And I have them to send me their court cases, and I look at them, and it basically just boils down to what I call Jerry Springer.
Well,
and
and let me say one thing. I've in my long life here, I've done a lot of things, from run a pool hall to be a child welfare worker with the State Department of Human Resources at one point. I remember my caseload we always had the hellions, the young kids that were middle school age and everything, that were out of control. And on many occasions, we were in the local courthouse with the circuit judge or someone regarding this child. And I remember many times, just what you were talking about, plans were laid out by the court, and the parents were there, and the grandparents and friends and everything. A lot of these involved well-to-do families, and some of them were poor kids and all that. But one thing I always found out, these plans weren't worth spit. The court can order a lot of things that's ridiculous. And I'm not saying that about what we just talked about this, but there were just plans made out that were, it was almost like they were just fanciful. This plan was just going to change his life and everything. And I knew that the child knew at that point that, this was just something else. It wasn't anything to it, and none of them ever succeeded. So, our current legislation amendments, the current joint custody law, it's been on the books since 1997, requires that a parenting plan be implemented by the parents, but the judicial system is not mandating that. Yeah.
They haven't since 97. These amendments are saying that each parent, upon the filing of a petition within 30 days, will present a parenting plan to the court. That lets the court know what the parent wants about their children, and if they can agree. And of course, we talk about, there may still be cases where attorneys have to get in and go in and mediate what those parents want and that type of thing with the parenting plan. But if you get down to a truly contested case among two fit parents, instead of a judge going in there and not really knowing what to do, then he's got a 10 or 12 page plan that's been filled and completed by each parent that he can look at and make some kind of determination of what needs to be done. That complies with federal law. That in 1997, when the federal government reformed the welfare acts that they had, they actually said they wanted parents making decisions for their children instead of the government. Mm-hmm. And currently, the state of Alabama is accepting federal grant money to promote what we're asking the legislature to do right here. They've been accepting money since 1997.
Now, that's another question. Y'all expand on it. In other words, millions of dollars are coming into the coffers of the state of Alabama in some manner from the federal government for these to be used for these plans. Is that
to have to create alternative child custody arrangements and the use of parenting plans?
What's happening to that money?
No, I don't really know. I've asked everybody that question in Montgomery. Nobody seems to know. But the facts are that the data that the state has presented to the federal government that I have access to shows that in the fiscal year 2009, which is the latest data that I have, that only 26 parenting plans were developed.
Let me give you another example of how the current law, if we've got time, is problematic. The current joint custody law basically says the court can give joint custody, but it doesn't have to. And one of the factors that it can consider is the past and present ability of the parents to cooperate with each other and make decisions jointly. So if one parent wants joint custody and the other parent doesn't, then that parent who doesn't want joint custody has the incentive to not agree, to not cooperate, to be able to go to the court and say, we can't agree on anything, Judge, therefore you shouldn't give it. That's a real problem in the current state of the law, and another reason why it needs to be changed.
Now, I remember one instance, Dinah, and you can maybe relate to this or not. Here in Limestone County, I was in the courthouse, and there was a circuit judge that had it was maybe 100 people in his courtroom, and I suppose you could say there were 50 on each side because there were ex-husbands and wives and parents, and there were all kinds of questions about alimony and child support payments and whatever. And now this is literally what that judge said. I want everyone to go out in the hall and decide what you're going to do and come back in here and tell me. Now, I suppose he was saying you go out in the hall and make a plan and come back and tell me. Well, you know, I thought for a minute there's going to be a riot out there. I mean, there was like 50 couples who didn't like each other too much, and it was bedlam. And I thought, that's the craziest thing I've ever seen. But now that I think about it, that might have been the best thing to do, because those parents decided something.
Well,
I don't know if that's...
It wasn't very detailed, though, and if you've got a template...
That may be true.
If you've got a parenting plan template to go by, if it's 12 pages long, that gives them some guidance to make them think, well, maybe I want to do this, maybe I want to do that, then...
And really, that judge his job is to make a decision when the parties can't agree. We just want to start the premise that parents who are fit should be treated equally, as opposed to the premise that's entered now.
All right, I know we hadn't done this justice within the time we got, but we've got we got another break coming up. I think we pretty well know what the problem is, and maybe there's some solutions to it. So when we come back, the three of y'all have the rest of this program to decide what you want here. We'll be back in just a minute.